Welcome to this session of the Welsh Affairs Committee, where we are taking evidence on the UK Internal Market Bill and the implications of this bill for devolution in the UK and in Wales specifically. I'm delighted that we're joined this morning by three prominent experts in the field of legal and constitutional studies. I'll ask each of them to introduce themselves in a moment, but in terms of a bit of housekeeping for our guests and members of the committee as well, if we could remember to keep our questions and answers as concise as possible, and that will give us the time to get through what I hope will be a very rich and rewarding session this morning. So, joined by Professor Aileen McHarg, Professor Joe Hunt and Professor Nicola McEwen. If you'd like to introduce yourselves, and then I'll ask each of you to answer an opening broad question about the bill. Professor McHarg.
Good morning. I'm Aileen McHarg. I'm Professor of Public Law and Human Rights at Durham University.
Thank you very much. And Professor Hunt? We may have a technical problem there. Professor McEwen.
Hello, good morning. Thank you for the invitation. I'm Nicola McEwen. I'm co-director of the Centre on Constitutional Change at the University of Edinburgh and a senior research fellow with the UK in a Changing Europe.
Okay, thank you very much. I'm hoping that we will get Professor Joe Hunt back very shortly. But in the meantime, could I ask you, Professor McHarg and Professor McEwen, just to give the committee, in very broad and concise terms, your assessment of what you think the UK government is trying to achieve with the Internal Market Bill, and give us a sense of how you see the importance of this bill and where it sits within the current constitutional architecture of the United Kingdom. Professor McHarg, perhaps you'd like to go first.
Thank you. So, in terms of what the UK government is trying to achieve, I think what it's trying this has to be seen in the context of Brexit and the removal of the cross-cutting constraint that currently exists on the powers of the devolved legislatures and, of course, also the UK Parliament to comply with EU law. The UK government is concerned that once we lift that common constraint, there could be regulatory divergence between the four parts of the UK, which creates barriers and costs for internal trade. Now, there is a process going on, as I'm sure you're aware, of negotiated common frameworks to identify areas where regulatory divergence would be particularly problematic. But this bill, I think, represents a kind of belt and braces approach. So it's something that will apply in addition to the common frameworks and provide a mechanism for removing barriers to trade in areas that are not covered by common frameworks, and we'll come on to discuss this, but also potentially in areas that are actually covered by common frameworks. In terms of the importance of the bill, I think it's extremely important. It's a major recasting of the devolution framework, although it doesn't explicitly, except in fairly limited respects, it doesn't explicitly alter devolved competences. It does so in some respects because it reserves state aid control, and it makes the bill itself a protected statute. So it does have some effect on devolved competence, but its major effect is to introduce a new type of constraint on devolution, which affects the territorial extent of devolved legislation and changes the ability of the devolved parliaments to effectively regulate their territories. Because what it will do is to tie regulation in areas that are caught by the bill to local producers and local service providers rather than to local markets. So it's in a very, very important and potentially very far-reaching and hard to predict way alters the ability of the devolved legislatures to effectively regulate their territories.
Okay, thank you very much. Professor McEwen.
I agree with everything that Aileen has just said there, so I don't want to repeat it. I suppose one observation is that the bill is trying to do different things, and what Professor McHarg just outlined is the core elements of the bill around market access principles and their effects. And it's a pity that those have been somewhat overshadowed by the other elements of the bill which affect and interact with the Northern Ireland Protocol, because I do think that there is the potential for the implementation of the market access principles in the way outlined in the bill has the potential to profoundly affect devolution and profoundly affect the status, in a way, of the devolved legislatures and their ability to legislate within their own territories in areas of their own competence. We don't know exactly the extent of that, because the bill is, of course, about the future, and the future is inherently unknown. We don't know the extent to which there would be regulatory divergence. All of the administrations have been working together where they think it's important to have, if not harmonisation, then at least a regulatory umbrella that is complementary and that isn't harmful in a way and doesn't raise some of the concerns that seem to be motivating this legislation. But there is a risk, actually, the bill, in trying to, and I've heard the term used, trying to introduce a backstop to the process to mop up things that might not be covered by common frameworks. There is the risk that the legislation undermines the work that has been going on for a number of years now in the common frameworks stream. I'm sure we'll talk about all of that.
Okay, thank you very much. Can I ask you both whether this concept of a UK internal market, which is a relatively new phrase in the conversation, certainly here at Westminster, is there a shared understanding between UK government and devolved governments of what that concept actually is, how it's defined and what it actually looks like in real terms? Do they agree on the essentials of the UK internal market? Professor McEwen, perhaps?
I don't think so. I'm not sure that the devolved government, certainly not the Scottish government, I don't think they would accept the principle that there is the internal market in the way that the UK government talks about it. Of course, there is a domestic market, and it's in the interest of all governments to try and ensure that there aren't disproportionate barriers within that. And that was even the case in the context of the independence debate several years ago. Even then, the Scottish Government was keen to ensure that there would be broadly the ability to trade across borders, even under that radically different constitutional scenario. So I think there's a shared interest in trying to avoid unnecessary barriers to trade, but there is quite a different view on what would be necessary and what would be proportionate. And perhaps just worth noting that going back to the UK government's white paper, the way that they defined the UK internal market was, I can't remember the exact words, but it was about the totality of economic relationships around the United Kingdom, which is an incredibly broad definition of an internal market, which I would normally assume to be about the rules that underpin those relationships. So no, I don't think there is a shared understanding or a shared acceptance between the governments.
Okay, thank you. And do you think it was always going to be necessary to legislate in this area, or actually is the fact that the UK government is legislating on the internal market perhaps I don't know, does it reflect a failure of the framework's negotiation process?
I don't think it was always going to be necessary. It might be necessary, but I think that would be a decision that perhaps would be better taken in light of experience. The frameworks process, I don't think, has failed. We've just seen the publication of a new framework. It's ongoing. Clearly, it's been interrupted somewhat by the priorities of governments in response to the COVID pandemic, but it's still ongoing and it's still underway, and there is the cushion in lots of areas of retained EU law to allow some time for a more cooperative process to unfold. Now, it might have been the case that there would be a need for legislative underpinning in a general sense, perhaps. There has been acknowledgement of a need for legislative underpinning in particular areas, and we've seen that already. But I think because this is all about the future, it seems to me to be perhaps more of a sign of a lack of trust on the part of all of the governments. We know that trust between the governments is very low, but perhaps a lack of trust on the part of the UK government that they would be able to produce cooperative arrangements through Four Nations approach, through the Common Frameworks approach. And this is a backstop, as I said, but it does seem to me to be something of a sledgehammer to crack a nut.
Okay, thank you. And Professor McHarg, would you have anything to add to that?
On your question of is there a shared understanding, I mean, I think all that I would add there is that there's a tendency to conflate the reality of highly integrated markets with the legal concept of an internal market. So an internal market is something that has a specific legal understanding. It's a trading area in which there is a set of common rules and a set of constraints to expressly remove barriers to trade. Now, in the white paper, in the explanatory notes and so on, there are references to the UK internal market going back to 1707 and the Acts of Union, but actually the legal supports for the UK internal market have always been historically rather limited in their scope and also asymmetrical. So there are different rules and constraints that apply in the different parts of the UK. So I think in that context, we never had a legally defined UK internal market. So and we've always had areas of significant regulatory divergence, areas which are not subject to and will not in future, like legal profession will not be subject to the UK internal market. So it's not surprising that in that context, and especially when these proposals have been produced at a very late stage in this process and very quickly and with a very short period for public consultation and so on, it's not surprising that there should be disagreement over what an internal market as a legal concept ought to cover and ought to look like. And just one other point, I mean, was this always inevitable? I think it was always one option. I mean, I can remember several years ago talking about the options that there might be for replacing EU law, and the idea of new single market or internal market cross-cutting constraints was certainly one of them, but it was not one that was being pursued. Other options were attempted, the initial attempt to kind of returning EU competences to the UK level and freeze out the devolved. That didn't happen. Then we moved to the Common Frameworks negotiated approach, and we've kind of come to this third option very, very late in the day.
Thank you very much. Really, really helpful. I understand Professor Jo Hunt has rejoined us. I don't know how much of that you were able to listen to. I'm really glad that you are back, but I don't know whether, just very briefly, in helping us set the scene for this morning's session, just give us your take on the importance of this bill within the UK Constitution and what it is that you think the government is trying to achieve through the bill and the trade-offs that it's trying to strike.
Okay, thank you, and apologies for the disruption so far this morning. I think it's a piece of legislation which, both in the way that it's been created and also its content, is perhaps sort of the antithesis of a sort of cooperative, collaborative, partnership approach to governance that I think we would perhaps hope to see, given 20 years of devolution to Wales and to Scotland, and longer for Northern Ireland. I think it's obviously it's an approach to try and ensure that devolved powers, or the powers that are held by the different parts of the United Kingdom, are exercised in a way that both are able to respect that matter of local choice, that reflect the fact of devolution, but also marry that with broader economic considerations and the economic strength of the United Kingdom as a whole. But it very much puts the balance on that latter sort of economic integration, strength of the economic union, and privileges that above all else as an approach. And I think it takes us into a very different place to that we've experienced over the last 20 years, whilst we've had devolution within the context of EU membership, where there's been, within EU law, there's been that opportunity to have an approach that allows local solutions, an approach that acknowledges subsidiarity, and that those things have been sort of baked into the system so far, and now there's that attempt to sort of shift away from that, but an attempt to do it in a way that hasn't proceeded in a partnership approach.
Thank you very much. All very, very helpful answers. I'm going to go straight over to Geraint Davis now, to bring Geraint in. You ready?
Yeah, thanks, Chair. Can I ask perhaps Professor Hunt first, actually? My understanding of the bill is that the regulations that don't meet market access principles won't apply, and that will mean that a very broad range of activity, in particular public health, environment planning, licensing, food standards that are currently devolved, Wales or Scotland won't be able to set higher standards, and for that matter they won't be able to set lower standards, because the standard will be set in England, and that is the standard. Is that correct?
The approach is one. I mean, the UK government has indicated that this doesn't impact devolved competence. Obviously, there is some explicit incursions into devolved competence in relation to, of course, state aid being reserved under this bill. But more generally, the government maintains there's no restriction on devolved competence, that they can still, the devolved legislatures can still adopt their own laws, their own policies in those areas. The effect is, though, of course, that the force of those laws is somewhat hollowed out, because they can only apply them to their own local producers or to direct imports from outside the UK.
Okay, well, can I ask the same sort of question to Professor McEwen, to basically ask, well, if we had a US trade deal and we had adulterated food coming in, for instance, hormone impregnated beef that gives rise to premature puberty amongst children, that was allowed, then is there anything the Welsh or Scottish government could do to stop that entering their territory, or to label it, to warn people of the health dangers?
If those products satisfied regulatory requirements in one part of the United Kingdom, they are eligible for entry into the markets in all parts of the United Kingdom. So if that answers your question. And
no,
similarly with labelling, you will note there has been a common framework around nutritional labelling and a Four Nations approach trying to agree that. But if, to take the example that you gave, if there was an imported product and it was deemed to be safe and satisfy regulations in England or wherever, then there wouldn't be neither the Scottish government nor the Welsh government nor the Northern Ireland Executive nor indeed the UK government, if it was the other way around, could prevent those products entering the market. That's the nature of the bill. That's the nature of the market access principles.
So if England wanted to let hormone impregnated beef in, Wales and Scotland couldn't stop it, could they?
No, I don't believe so.
Okay. And then can I ask Professor McHarg, then, a similar sort of thing. If Wales wants to ban 9 single-use plastics, which it does, and England was to ban 3, then we end up just banning 3. That's correct, isn't it?
Well, yes and no. So for Welsh producers, Welsh service providers, Welsh producers, it would be that there's a ban on 9. But for anyone coming from any other part of the UK, those additional bans wouldn't apply. Just one complication I want to throw in here is you could envisage, with your hormone impregnated beef example, one thing that a devolved legislature might try to do, unable to ban the sale of hormone impregnated beef, but you might imagine circumstances in which they would attempt to ban the use of it, say for school meals. Now, bans on use, whether those are caught by the market access principles, and if so, which one? Is it not mutual recognition or non-discrimination? It's really unclear. So there are areas of unclarity here which are also problematic. These rules do not simply reproduce EU law. I mean, there's been about 50 years of experience of internal market rules under EU law, so people who know about those things have a fairly good understanding of how they apply. But these principles under this bill are not the same, and so we have a whole new set of areas of uncertainty around about what may or may not be possible.
But if I may, I don't sort of disagree with you, but I mean, if there's a clear rule on mutual recognition and non-discrimination, and I'm trying to sell hormone impregnated beef and I judge it in England to be safe, who is the school? Although, the Welsh government won't be able to stop those products being sold in schools because they'll be deemed to be safe. I can't see there's any ambiguity at all. Professor Hunt, have you got a view on this?
In terms, right, so the situation at present, of course, under the devolution settlements, in terms of import and export of food products, animal welfare, animal products, that there is the capacity there, the legal capacity for Wales, Scotland to do that, yeah, and under EU law that would be permitted, and there would be an independent system of verification in terms of food safety with the European Food Standards Agency. And I suppose there's concerns around the architecture that we have, the governance architecture for handling those sorts of issues, that it is a 4 nations approach to those sorts of issues rather than being able to be driven by one part of the union. And given its size, given its market size, that's likely to be driven by what England wants.
I mean, under the internal market, but England will drive these standards, and if they have lower standards and they want chlorinated chicken and hormone impregnated beef, then we in Wales or people in Scotland will have to have those without impeding the trade of those. That's correct, isn't it? And in the past, they wouldn't have to. That's correct.
I mean, in terms of the sorts of grounds for justification that are available under EU law, that they are much broader than those that have been reproduced or sort of attempted to read across into UK law.
And under EU law, there is this devolved competence and power to have your own public health, environment planning, food standards, etc. Is there anything to stop the government changing the internal market bill to allow that divergence and choice and devolved competence? Because it's worked up to now, all right.
Well, I think that's very much the point. These things have, what is the case for moving away from the situation that has existed for the past, well, as long as we've had EU membership, but within that, as long as we've had devolution. Our courts are used to applying these principles. Our producers, importers know how they work. So the case hasn't been made for why a more restrictive reading of any of these rules is necessary.
And Professor McEwen, can you think of some good economic benefits to having this new approach, which overrides, it seems to me, the devolutionary settlements in Scotland, Northern Ireland and Wales? Can you think of any good ideas?
I think some of the surrounding documentation that accompanied the legislation and indeed the white paper as well do suggest that the ability to negotiate trade agreements is part of the rationale for this. Indeed, the Common Framework Principles also included that as part of the rationale for harmonising where appropriate. And I think that's, you know, and it's reflected in the questions that you're posing. I think that's partly why there is such concern that this could be a tool to alter the regulatory standards and leaving the devolved legislatures with the inability to do very much about the goods that are entering their markets from elsewhere. So I think we don't know if that will be the case. The UK government has committed to maintaining high standards, at least verbally. So we do not know what the future holds, but I think it's a reflection of the lack of communication, perhaps, between administrations, and also the lack of trust in the direction of travel that is contributing to the concern around the constraints in the bill.
And so finally, just by way of example,
last question, please.
Yeah, okay, sorry, Chair. By way of example, I think the Welsh Government is trying to introduce a Clean Air Act that would presumably set, you know, legal limits on particulates and PM2.5 and this sort of thing. Now, under the new internal market, if they set a standard which isn't applied in England, that standard won't apply, will it? Is that right, Professor McEwen?
I think I'll leave that one to the lawyers. I'm not familiar enough with the proposed legislation.
All right. Does anyone want to answer that? Just one person? Professor Hunt? No?
Well, if those...
Basically, environmental standards, if they're set in Wales, they won't apply. If they're not, if they're lower in England, that's the basic question.
It depends what they are bearing on. If these are bearing on the nature of a product to be sold or the way in which it's sold, sort of surrounding that, then it would be potentially caught by these measures. But sort of more general environmental protection legislation in terms of emissions, may, you know, if it's not got that connection to sale, then the reach of these measures will not necessarily attach to them.
All right, I'll leave it there. Thank you, Chair.
Thank you, Geraint. Virginia Crosby, I'm going to bring you in next, if that's okay.
Thank you, Chair, and thank you to the three professors for their time and expertise this morning. I have two questions. If I could start with Professor McEwen. You previously suggested that the market access principles could result in England dominating the UK market, and I was wondering whether you could please expand on this. Thank you.
Sure. I mean, it's a matter of scale. So the English market is just so much bigger than the others, and that for businesses trying to enter that market from other parts of the UK, and for the scale of goods and services entering Wales, Scotland, Northern Ireland from that considerably larger market, does seem to suggest that the regulatory standards that are set in England will have a disproportionately large effect compared to the others. So one is just scale. The other reason is that, of course, England is, the regulations that are set for England are set by the UK government and the UK Parliament, and they do not have, these institutions do not have the same constraints on them as are imposed on the devolved institutions as a result of this legislation.
Thank you very much. And could I ask that question to, have we got Professor Hunt, please?
Yes, yes.
Thank you.
Yeah, just to concur with what Professor McEwen has said there, but also to pick up that point about the impact on rules that are made for England by the UK Parliament, and to, you know, is the assumption here that acts of Parliament may potentially be disapplied, or will those, if standards are set in acts of Parliament, will they overtake what is in this act of Parliament? And again, it's a reflection of that, the difference of the powers that the different parliaments have, but the fact that Parliament, the Westminster Parliament, is acting for England, but that brings with it the sort of the guarantees of parliamentary sovereignty. So there's not an even-handed approach to the way that the different parts of the UK are being treated in this legislation. It's very much a sort of tool to keep the devolved legislatures in check, as I read it.
And what do you read as some of the positives relating to this, Professor Hunt?
The positives in terms of the internal market bill?
Well, no, yeah, well, yes. No, just relating to the in terms of any of the dominance the other way around. I talked about England dominating, and then in terms of the devolved nations, the other way around.
So
I can't hear you. Sorry.
No. So in terms of dominance the other way around, that in
yes,
I mean,
yes.
fact is, then there needs to be space for local choices, that devolved choices, to be able to operate effectively and to have a force rather than sort of being hollowed out by the reach of regulations or laws for England. So it's how we balance that, how we balance a commitment to a union and to an internal market for that union, but also respect for local choices. And this bill doesn't yet do that.
Okay, thank you. And Professor McHarg?
Just to pick up on your last question, I mean, it is technically possible under this legislation for higher standards in England to be undercut by lower standards from the devolved. But there are two problems with that. One is the scale issue. So as things currently stand, the English market is so much bigger than the devolved markets that without something changing very significantly, a devolved government aggressively going out to attract suppliers to base themselves in Wales or Scotland on the promise of lower standard, it's actually quite hard to see significant undercutting from the devolves. But the other point is the other one that's been made. The UK Parliament, if it sees that happening in relation to the standards it's set for England, has the ability to at least expressly and possibly implicitly, but at least expressly, to set aside the market access principles, whereas the devolves cannot, because the UK Internal Market Bill for the devolves will be a protected statute that they cannot repeal or modify. So there is that inherent asymmetry, one of size and two of the ability to say, hang on a minute, we don't like what's happening here. The UK government for England can do something about it. The devolves can't.
Thank you. And then my last question, Professor McEwen, you've suggested that the bill could have a negative impact on legislative innovation. Why do you believe this to be the case? Thank you.
I think it's broadly a comment on how policy divergence is regarded. There seems to be an implicit assumption within the bill that regulatory divergence is a bad thing, is a barrier to trade and therefore something to be avoided. And my point there is that we have one of the strengths of devolution is that you have the ability to set policies that are responsive to local needs, to local preferences, to ideological differences between the administrations. And sometimes that also just frees up the space for different administrations, perhaps on a smaller territorial scale, to try something different. And there's a lot of the areas where that has happened in the past have been around social policy issues, and if they didn't have market implications, that will continue to happen in much the same way. But where they did have market implications, minimum unit pricing, for example, or the use of single-use plastics that was already mentioned in the forthcoming Welsh legislation. So these sorts of things, where they are being tried differently in one part of the United Kingdom, it may not be possible to see the potential benefits of those policies if they can't be applied to everything that's taking place in that territory. So if you minimize the societal benefits, then you minimise the potential for that policy for us to see if it's going to work, for us to see if it's going to help to do something different that might be emulated in different parts of the United Kingdom. And it's interesting to note that the impact assessment that accompanied this legislation did acknowledge that. It did acknowledge that societal benefits resulting from different regulations in different parts of the United Kingdom would be foregone. And that is a price that the government seems to think is acceptable in order to avoid barriers to trade. So I think it's my concern is just the way in which divergence is viewed negatively as a harm, whereas I think it can be a benefit, and it can be beneficial not just for the part where the innovation takes place, but for others as well.
Thank you. And that question to Professor Hunt, please, on legislative innovation.
I think we may have lost Professor Hunt.
Okay. Professor McHarg?
I would agree with everything that Nicola has said so far. I mean, just to amplify, Nicola has pointed to the fact that by innovating, you may not be able to, by not being able to impose those innovative standards across your whole market, you don't see the benefits. But also, you are placing your own domestic producers potentially at a disadvantage if those new standards are burdensome and costly. So there's a kind of double whammy, as it were. You don't see the benefits, and you impose a cost. The other issues, I guess, are around about the freezing of differences. So existing regulatory differences can continue to apply, but if they are subject to substantive change, then they're brought within the purview of the bill. We don't know what substantive change means. That's not defined. But again, that's a disincentive to try to update your regulatory schemes to improve them to address weaknesses and so on. So I think in that way, it also potentially undermines innovation. The last point I wanted to make was, there is some opportunity for some types of regulatory standards to justify them, particularly if they fall under the non-discrimination rule. There are limited opportunities to justify them on public policy grounds, albeit much narrower than currently exist under EU law. But what concerns me in terms of the sort of pure innovation space, the test under the bill is, this is the divergence is reasonably necessary to meet a legitimate aim. Well, if you take something like minimum alcohol pricing, which had to go through this kind of justificatory process under EU law, a lot of the discussion was about whether these measures were necessary because of Scotland's particularly severe problems with alcohol abuse. Where you're talking about pure innovation, it's not that there's a particular problem here, it's just that a devolved government wants to try something new, or there is a political demand to go further. But, elsewhere in the UK, it's not deemed necessary for public health or public safety or whatever to make that change. Then I worry that it won't be possible to meet that reasonably necessary test. Again, we don't know what that means. It's not the same wording as under EU law. We don't know how it will be interpreted and applied by the courts.
Okay, thank you. Thank you, Chair.
Virginia. I'm going to bring in Rob Roberts now, who had, I think, a supplementary question to an earlier answer. Rob.
Yeah, thank you, Chair. It's a very specific question. I was going to ask to both of the legal professors, but we seem to have lost one of them, so I will go with no offence, Professor McEwen.
No, none taken.
Legal question. So, Professor McHarg, just going back to one of the questions that my colleague Mr. Davis asked earlier on with regard to, as he kept mentioning it, a dozen or so times, hormone impregnated beef. In the chamber earlier on this week, the DEFRA minister said that trade negotiations won't compromise on high environmental protection, animal welfare or food standards, and our current import standards are enshrined in existing law, which include a ban on importing beef produced using artificial growth hormones and poultry washed with chlorine. And the European Union Withdrawal Act 2020 carries those existing standards on environmental protection, animal welfare and food safety across into UK law. Changes to that legislation would need to be brought before Parliament to specifically vote against those regulations. So would you agree, Professor McHarg, in a very short answer, that actually we won't be able to do any of the things that Mr. Davis was talking about earlier unless we specifically vote to do so?
I mean, you're right that where there is an existing domestic rule, it would have to be changed to comply with a different rule in a trade agreement. That's a basic principle. I mean, I suppose what the concern would be is that the UK Parliament can change it for England, not attempt to explicitly change it for Scotland, Wales or Northern Ireland, and therefore not get into any problems about a requirement of consent under the Sewell Convention. So, you know, we don't pay that political price. Instead, we make the change for England, which there may or may not be support for, but there may be.
Okay, just on that point though, what I'm trying to get to is, in order for the beef and the chlorinated chicken and all of those things to be able to be imported, we would need to specifically change the regulations to allow that, because currently and going forward with the EU Withdrawal Act, they wouldn't be allowed. Is that the case?
Well, I don't know the details of food standards law to be able to give you a definitive answer, but in principle, what I'm trying to say is the change would only need to be made for England, and then it applies by default in Scotland, Wales and Northern Ireland. So I think one of the kind of clever aspects of this bill, if you like, is that it depoliticizes the imposition of these standards on the devolved parliaments, the devolved territories, because it's not the UK Parliament saying we are going to change devolved law in order to implement this trade agreement. It's left to individual traders, individual businesses to enforce these rules by default.
Okay, let's move on from this discussion. Thank you all. Beth Winter.
Thank you, Chair, and thank you, witnesses, for coming today. As you'll be aware, there has been absolute uproar in Wales about this bill and the way that it's been introduced. So we've got the First Minister, Mark Drakeford, saying it represents a smash and grab on the devolution settlement. Jeremy Miles is saying it's an attack on democracy. And that the Welsh Government will do everything to challenge the power and the race to the bottom the bill represents. But on the other side, we've had the Secretary of State for Wales saying that he'd love to know what powers the Welsh Government that currently that we enjoy, that we won't be able to enjoy when the bill becomes law. Who is right? Is there anything that the Welsh Government has done previously that you believe would not be possible under the provisions of the bill? And I'd like to ask, is Professor Hunt with us now or not?
Hi, yes, I'm back on the dial-in.
Okay. So could you respond, please?
Okay, so in terms of things that have been possible previously that might not be possible in the future.
Mm. Yeah.
So, and I suppose, you know, we look at, obviously, so much of legislative decision-making has taken place within the context of EU membership. So a lot of what has been done, but not everything, but a lot that's been done in relation to products, services, trade, is within the context of EU law, that it has to respect free movement principles, but it also, a lot of it is giving effect to EU regulations, EU legislation. So whether that is something like the single-use plastic measures that have been taken so far, at the moment that's done under an EU directive, and the proposals for future measures on single-use plastics is again a reflection of what is in an EU directive that will apply for for all of the European Union. You know, at present, that is possible. Wales can introduce that legislation, but in the future, it may not be able to, or it will be able to introduce it for its own producers. But its impact may be sort of hollowed out if the rest of the UK or the parts of the UK don't also introduce that legislation.
Okay. Thank you. And Professor McHarg?
I'm going to find it difficult to give you examples from Wales because I'm more familiar with Scotland. So a couple of examples. There is in Scotland currently a ban on sale of air weapons over the internet. Air weapons have to be sold face to face. In future, that will be subject, if such a change were to be made in future, that would be subject to non-discrimination principles and would have to be justified as reasonably necessary for public safety. And unless the Scottish Government could show that there is a greater need to regulate firearms sales in Scotland than elsewhere in the UK, then it couldn't be applied to sellers of air weapons from elsewhere in the UK. The other example in Scotland would be deposit and return scheme that has been legislated for, but is not for drinks, single-use drinks containers, is not yet enforced. So this will be caught by the legislation. It's quite complicated as to how exactly different aspects of the scheme will, how they will be caught. But under EU law, that is able to be justified for its environmental benefits, but there is no opportunity to justify it on environmental grounds under this bill.
So can I just pick up, in terms of the examples you've given then, would you agree that this, that Mark Drakeford is right in terms of saying that this is a power grab and that it will undermine the ability of the devolved nations to make rules and regulations ourselves?
Well, I mean, I think there's a sort of a semantic difference here. The UK government is right to say that it doesn't remove competences that are already there. But what it does is severely undermine the effective use that can be made of those competences and severely undermine the ability of the involved legislatures to do things differently in their own territories. So that, it's a kind of form versus substance distinction.
Okay, thank you. Finally, Professor McEwen.
Yes, just to return to the point that Professor Hunt was making, we can look back and we can find probably a handful of examples of where legislation or regulations that were introduced previously in Wales may fall under the scope of this legislation and therefore not apply to products and services entering Wales from elsewhere in the UK. But I think the point is that previously, all of the administrations were operating under an EU regulatory framework, and that will no longer be the case. So the concern is that the potential for this to affect legislation and regulations in the future is much greater if, as we expect at some point or other, that administrations within the United Kingdom, that legislatures within the United Kingdom depart from EU law and EU regulations. So the potential is much greater for the future than it would have been if we were looking to the past. But I think, yes, it is about the scope. And my understanding of the Welsh Government's position is not that it is opposed to support for a UK internal market, but I think part of the problem is the way that this process has got to this stage and the top-down nature of it. And the Welsh Government, unlike the Scottish Government, did participate in the discussions with the UK Government on a UK internal market. They did participate in the discussions that were led by the team in Bays, but were cut out from the process in the months leading up to the legislation. And that, as much as the content obviously matters, the content is important here, but it's also the process that has led to it that has caused so much anxiety and anger on the part of the Welsh Government and indeed the Scottish Government as well. And it's interesting to note that these are governments that constitutionally come from very different places in some senses, but are very much on the same page in their response to this legislation.
I think that's fair, but and I'd also add, and we're coming on to this later, in terms of the common framework, you know, and there's lots of scope already in existence for you know, the nations to cooperate anyway. So, but we'll come on to that later. Thank you very much for now. Diolch yn fawr, Chair.
Thank you, Beth. Ben Lake.
Thank you, Chair, and thanks to all the panellists for their time this morning. I'd like to ask further question on the exemptions to the market access principles, which we touched on earlier on, and in particular, whether the panellists might comment on the implications for devolution of the UK government having that right or that power to decide and amend the exemptions, and as a add-on, perhaps, how this compares to the situation under the EU internal market and its operation. I don't know who would like to go first.
Oh, yeah. Yes, I mean, it's very, very surprising that the UK government has this unilateral power to change the scope of these principles potentially very, very substantially. I mean, if you change the justifications for indirectly discriminatory rules, you know, that significantly affects the ability of the devolves to regulate effectively, and that could be changed in the direction of adding new legitimate aims, or it could be changed in the direction of taking away what are already a very, very narrow set of aims. So, you know, this is a very significant power. There is one provision, the provision which allows ministers to change the definition of what is covered by the market access principles versus the non-discrimination principles. There's a duty to consult the devolves for that power, but for the other ones, the amendment of Schedule 1, Schedule 2, an amendment of legitimate aims, there's not even a consultation obligation, which is really, really surprising. And the idea of UK ministers having the ability to change unilaterally things which affect the devolved legislatures' effective legislative powers, I think, is one that in principle is pretty objectionable. If you cast your mind back to disputes over the EU withdrawal bill, the EU Withdrawal Act of 2018, you'll recall that there was a huge amount of controversy at that time over similar ministerial powers to freeze areas of retained EU law and affect the scope of devolved competence. The compromise that was reached on that occasion, which allowed the Welsh Parliament to grant its consent, was that consent had to be sought from the relevant devolved legislature for the exercise of those freezing powers. It could be overridden, but any decision to override it has to be expressly justified before Parliament. So there is there's a relatively strong procedural mechanism to deal with this constitutional anomaly of allowing ministers, UK ministers, to change, to affect the scope of devolved competences. So I would expect to see something equivalent to that in this bill, given how important these ministerial powers could turn out to be in practice.
Hunt, perhaps?
Hello, yes. I think if we want to draw parallels or identify where there are some very significant differences between the approach taken in the UK Internal Market Bill and the approach taken under EU law, the starting point is very different. In EU law, in EU free movement law generally, there's a distinction drawn between those measures which are on their face discriminatory, and there's a set of treaty-based exemptions for situations where member states may draw distinctions between goods coming, their own goods and goods coming from other countries. And there's a treaty-based set of derogations which are already significantly broader than the ones that are recognised in the UK Internal Market Bill. But more generally, for all other measures, for anything else that impacts or hinders access to the market that is caught by that, what is the mutual recognition principle as expressed in the Internal Market Bill, that there's a much wider open list of justifications. It's not a closed fixed list. It's public policy reasons that the member state can show are justified or proportionate to in their response to achieve a policy aim. And those things include environmental protection, consumer protection, respect for social and cultural choices, respect for pluralism of the press. These are all things that have been recognised as grounds, the exercise of that mutual recognition principle. The mutual recognition in EU law is only a presumption. It's a rebuttable presumption that you accept products from other member states. It is a sort of a balancing act that takes place, balancing out the free movement as against sort of local choices. And the way that the UK bill operates is very, very different. It sort of raises that mutual recognition to more or less an absolute rule. So we see a very different approach there. And as you say, as Professor McHarg said, that process of determining what is caught anyway by those rules, that's for the future is a decision for Secretary of State without the effective input of the other ministers from UK, from the devolved administrations. And at the very least, we should be seeing something equivalent to the provisions in the Withdrawal Act around sort of a consent process around that.
Moving on slightly to look at the Office for the Internal Market, what are your views on the suggestion made by the Welsh Government that the Competition and Markets Authority is not currently a suitable vehicle for the Office of the Internal Market? Perhaps we should start with Professor McEwen.
Yeah, I did see that was the position they had taken, and I'm not quite sure of the reasoning behind it. Perhaps it reflects a concern that there mightn't be an understanding of the broader policy landscape that exists in all of the different parts of the United Kingdom. And the Competition and Markets Authority, of course, is quite narrowly focused on competition and markets, and that's a lot about what this bill does, but this bill also profoundly affects devolution. And for my part, I would hope that while it's perhaps legitimate for somebody, this one or another, to monitor and evaluate the effects of the market, I think it's also appropriate for there to be monitoring and evaluating the effects on devolution, because that's these are twin things here, and that's missing so far from the bill.
Professor McHarg or Professor Hunt, do you have anything further you'd comment on that question?
I mean, the Competition and Markets Authority has a broad remit currently. It deals with sort of standard competition inquiries, abuse of monopoly position, and so on. But it also undertakes broader market investigations, for instance, in relation to regulated industries and so on. It can deal with consumer super complaints. In terms of, it depends what you're looking for here. I mean, I guess there's a whole set of criteria around about the independence of anybody undertaking this kind of role, and I would have thought that the provisions for appointments of panel members and security of tenure and so on are appropriate. The Office for the Internal Market will be a specific panel within the CMA, so it won't just be one of their generic panels. It will be separately appointed, and appointments have to be made in consultation with the devolved governments. So I guess the other issue is Nicola said, who is going to be appointed? Are they people who will have an appropriate understanding of the principles of devolution, and what are the criteria that they will be applying when they undertake their their investigations. The Internal Market Bill disapplies the general duty to promote competition and replaces it with a concern with the effective operation of the internal market. But effective operation of the internal market is itself extremely vague and potentially very contentious. So I think it's not, my concern would not be so much about this body or the use of this body, but rather who is being appointed to it and what criteria are they taking into account when they make their when they carry out their investigations.
Thank you. Professor Hunt, what role do you think the devolved legislatures could play in scrutinising the Office of the Internal Market?
I missed the question. I was just asking. Repeat the question, please.
What role should the devolved legislatures play in scrutinising the work of the Office of the Internal Market?
Well, I mean, the OIM, which is within the Competition and Markets Authority. Competition and Markets Authority is a non-ministerial department of the UK government, and I think we would perhaps like to see a more four nations approach being taken to the governance architecture, and at the very least have a situation where, rather than simply being consulted, that each of the four nations makes nominations to that body, so that there is a sort of a sense of joint ownership of those institutions that are going to be making these decisions that are market-driven but have very, very significant impact and implications for devolution. And I think, given that significance of that reach into the devolved settlements, that there's that need for more of a representation of the devolved nations within that body.
Finally from me, Chair, the UK government has indicated that intergovernmental processes will play quite a key role in managing disputes between administrations in relation to the UK internal market. I'm just interested to hear your thoughts on whether or not these current mechanisms and processes are robust enough for such a purpose.
No, in a word. No, clearly, I mean, and there's widespread recognition that intergovernmental relations in the United Kingdom is not fit for purpose. There have been countless inquiries in parliamentary committees across the United Kingdom that have come to that conclusion. And as you know, the governments have been working on a review of intergovernmental relations, and I understand making some progress finally within that review. But while this bill and the provisions within it utterly rely on effective intergovernmental relations to manage differences and to manage disputes, at the same time, the process that has led to it and the nature of the bill and the nature of the constraint on the devolved institutions does risk making it very difficult to make sufficient progress within the review of intergovernmental relations to help us to get to the stage where they are more effective and they are more fit for purpose. This is doing nothing to support the trust that is essential to effective intergovernmental working. And I think we would need some sort of forum, whether it's a joint ministerial committee or something else, that brings the different administrations together to review the functioning of the internal market, to review the governance of common frameworks, and if this bill proceeds as it is, to review its effects. And we don't have that just yet. And I think part of the problem in all of this has been about the process. It's one of the other big differences we talked earlier about, the difference in the scope of exemptions in this bill compared to EU law. But one of the other obvious differences is the process that leads to the rules being adopted in the first place. And this, in contrast to common frameworks, in contrast to the EU internal market, this has not been a co-produced process. And that, I think, is one of the biggest problems and one of the biggest hurdles in getting us to the point where we have an intergovernmental relations machinery that can help support this and help make it work.
Professor McEwen, Professors Hunt and McHarg, would you agree with that viewpoint?
Yes, I would. I mean, think Nicola is right to describe the weaknesses in the current approach and also the importance of intergovernmental relations. Could I just come back on your previous question to Professor Hunt? You asked about, is there scope for the CMA to be more accountable to devolved legislatures? There is a precedent that could be drawn on here. So Ofgem and I think also Ofcom have a duty to answer to the Scottish Parliament, at least. That was a change made in the Scotland Act 2016. I'm not sure about the other devolved legislatures, but there is a precedent for making UK-wide regulatory bodies answerable to the devolved legislatures, which could usefully be emulated here. Sorry, no, that was on your previous question.
No, not at all. Thank you, Professor McHarg. That's very, very useful. Professor Hunt, finally, do you have anything to add on the question of whether or not the existing dispute resolution mechanisms are appropriate for the task of resolving any disagreements arising from the Internal Market Bill?
I think, well, as far as dispute resolution concerned, on an intergovernmental level, there is, Professor McEwen and Professor McHarg have very clearly shown the limitations and the concerns around the process as it stands. But I think there's another point about we don't know where that intergovernmental dispute resolution fits as alongside sort of resolution in other ways, whether we're going to be using the courts for this, whether these are going to be enforceable principles, and that's still not clear. We know that these provisions are said to have direct legal effect. There's a suggestion that the courts are going to be involved to some extent in their enforcement, but it's not clear how. And where that balance lies between intergovernmental settlement of these issues or the use of litigation to settle those issues. We have a new clause 12 that has been introduced into the bill, which gives powers to the Secretary of State to make guidance on how enforcement will take place. But that doesn't bring us any clarity at all. It just leaves the question open as to how it's going to work.
Thank you, Chair.
Thank you, Ben. I have Robin Miller with a supplementary.
Thank you, Chair. Listening with great interest to this, and apologies for joining the meeting late. I was held up with other business. I think it'd be very helpful, briefly, as a supplementary chair, if the panel members could clarify for the committee and the record, they confirm the UK's sovereign nation status and the limits this places on equivalence between the UK government and the devolved administrations. Thank you.
Who's that to, Robin?
Each of the panel members, please. Thank you.
Well, I'm happy to confirm that the UK Parliament is a sovereign parliament and the devolved legislatures are not sovereign legislatures. That is true, but it doesn't make it any less problematic in this context that we're replacing a set of constraints that apply symmetrically with a set of constraints that apply asymmetrically.
With respect, that's exactly the point of the question. It is asymmetric because the UK government is a sovereign power and the devolved administrations are not. So those powers that return to the UK government are those which have been vested in and lay with the superior EU, and they haven't been passed to the devolved administrations. But I apologise, Chair, I don't want to get involved into the discussion at this point. I may come back later, but I'm very interested if the panel members could clarify this for the benefits of the committee. Thank you.
I mean, they have returning EU competencies in areas that are otherwise devolved under the terms of the EU Withdrawal Act do fall to the devolved parliament. There was a very long dispute over that, which was resolved in favour of respecting the existing devolved settlement. Now, it is certainly true to say that the powers of the devolved legislatures are not legally entrenched. The Sewell Convention was supposed to, and for 18 years, 19 years, operated as a form of political entrenchment. But, from my perspective, you're identifying a problem here, not a justification for the approach taken in this bill.
Robin, have you finished your question?
If I may
Sorry, Joe, go on.
The question was to each panel member, please, Jim.
Yeah, absolutely. Westminster Parliament, of course, is sovereign within the context of the constitutional conventions that operate there, but also it's sovereign to the United Kingdom. But this bill sort of emphasises England's benefit of sovereignty of the UK Parliament. That there is no parity there in terms of how the four different parts of the United Kingdom are treated under this legislation.
For my part, I don't really have anything to add. I'm not questioning the view of the sovereignty of the UK Parliament and the lack of sovereignty, in a sense, in the same way that the lack of equivalence of the devolved legislatures. It's merely, all we're trying to do is to point out how the bill potentially changes the system of devolution that the UK Parliament created, and it will have effects on that. It will have constraints on that. And it's for the UK Parliament to decide whether that's the system that it now wants to create, but recognising that that has consequences for the scope of what the devolved institutions can do, and possibly wider consequences too.
Thank you, Chair. That's been a very helpful clarification.
Thank you. Ruth Jones.
There we are. Thank you, Chair, and apologies for being late this morning. I had to come from the chamber, so I do apologise. I'm going to move on to spending powers now. Looking at Section 6 of the bill, it's been, Part 6, it's been suggested that this could be used by the UK government to administer the Shared Prosperity Fund. I just wonder what you think the implications of the UK government using the powers for this purpose could be. And if I start with Professor McHarg, please.
Thank you. Yes. The purpose of the spending powers seems to be, there seem to be a number of potential purposes here. So in some at times it's talked as being the basis for shared prosperity funds, so replacing EU funding streams, but there's also references to this as being the basis for post-COVID recovery spending. And also the basis for spending to support UK values or British values, whatever that means. So part of the justification is the replacement of EU funding, but the purposes may be wider. The difficulty with this provision is that it is very, very wide indeed. It sets out a number of types of expenditure that are permitted, but with no indication of how it might be used, what sorts of amounts of funding we're talking about, whether it would be sort of supporting one-off projects or the basis for establishing funding streams. I mean, it's all very, very unclear what this power, or how this power might be used in future.
Thank you. Shall I move on to Professor Hunt? Do you have anything to add to that? Is Professor Hunt still here?
Yeah, obviously the issue of any replacement funding is particularly a sensitive one in Wales, where there has been very significant funding in comparison to the rest of the UK. That Wales has been a net beneficiary of EU funding, and we know that if this is, I mean, there's been commitments made about maintaining the same levels of funding as being received under the EU programmes, and that there would be sort of continued respect for the devolution settlement throughout that. So if this is the Shared Prosperity Fund, then there are certain guarantees that that don't necessarily sort of flow through within the bill, and there's been some very sort of provocative language around it that has been sort of quite challenging. So again, it's one of the other aspects of the bill where we simply have no clarity, and it's we've waited a very long time to know what the Shared Prosperity Fund is going to look like and how it's going to work. Currently, we know sort of WESO, part of the Welsh Government, has had a central role in the administration of those funds on a partnership basis. but there's no suggestion of what the architecture is going to look like in the bill. So again, it's there are concerns because of the lack of clarity, the lack of guarantees here.
And just, I suppose, a supplementary to Professor Hunt, you mentioned the guarantees. What sort of guarantees? I mean, you've got a legal background. What sort of wording would you like on guarantees?
Well, I mean, in terms of how it's approached, there could be commitments, as there are in the EU regulations that we see in this area, you know, towards a model of partnership and acknowledging that the different roles that different levels of government might have within that process. But there's nothing at all on the face of the bill around a sort of a partnership approach. But that, you know, that is something that could be incorporated.
Okay, well, thank you for that. Professor McEwen.
Yeah, just perhaps one, I mean, I agree with everything that's been said so far, but just to add one thing, the structural funds was very much a needs-based spending and needs-based allocation, and obviously that has been beneficial for Wales up until now, and we just don't know enough about what is anticipated with the shared prosperity fund element of this, or indeed how the shared prosperity fund will be folded into this broader general spending power, which is potentially very broad. And I agree with Professor Hunt. It's the concern is about, and this is reinforced by some of the statements, including by ministers that have surrounded the bill, is the extent to which this will be in cooperation with the devolved administrations or in competition with them. And some of the language has not helped. And in a sense, it's a pity that this has been tacked on to, it does feel like it's tacked on to an internal market bill, because that has meant that we haven't had sufficient scrutiny of this element. There hasn't been the same sort of requirement in a sense of the detail of what is proposed here, because we simply don't know what the intention is, and we don't know how it will interact with the existing system of territorial finance.
Thank you very much, and thank you for clarifying that the uncertainty that actually is part of the bill. So that's very helpful. Thank you. I'll hand you back to the chair now.
Ruth, I have Tonya Antonelli with supplementary.
Yeah, just a quick question. There's all this uncertainty and time marches on. A quick answer from all of you. How much longer can we wait?
About what specifically?
Well,
everything in the bill, or just the spending power?
Basically about the bill, you know, how long, you know, this uncertainty around the spending powers and the bill and the shared prosperity fund, you know, we're getting to a situation where it is getting ridiculous and things need to be sorted out. You know, and the sooner the better. What are your thoughts?
Yeah. I mean, I think, sorry, go ahead.
Sorry. From the perspective of the bill generally, obviously some parts of it can definitely wait. There's not been the case made that there's a need for any of the horizontal market access principles, and the common framework should be allowed to see what happens there. But in terms of shared prosperity, it's getting incredibly late, and yet this is still the best that we get. We don't even know whether this is the shared prosperity fund, and it is incredibly sketchy. So it's very, very late in the day, but this isn't the solution.
Okay, thanks. Do either of the rest of you want to make a comment?
No, I completely agree. I mean, I do think that there is an urgency now around the shared prosperity fund, or whatever it will be called, and we absolutely need to see the details of that. But a lot of the other elements of the bill can wait. They can wait until we see if a cooperative approach can be met through the frameworks process, and that does seem to be making progress. And retained EU law, remember, does carry us a bit around some of the regulatory frameworks that are brought into the domestic legal framework. So that does buy some time to work on alternative ways to do this, rather than what appears to be a rather blunt tool.
Thank you very much. Thanks, Chair.
Thank you, Tonya. Rob Roberts.
Chair, and appreciate the time being given by the panelists today. I'm interested to know, with regard to projects and spending in the devolved administrations, what potential there is for UK government to bypass the devolved administrations and seek to work directly with local government in regions and other stakeholders to deliver projects rather than through the devolved assemblies themselves. And we'll start with Professor McEwen.
Well, the general power, the general spending power that the bill provides to the UK government suggests that they would be able to do that. And indeed, the accompanying documentation suggests that this would be a way for them to work directly with local authorities, with sporting bodies, with cultural organisations, and so on. But it would depend on the scale of what was intended here. And if it was around a big infrastructure project, for example, a bypass, for example, then that would inevitably intersect with other areas of devolved competence, like planning, like environmental assessments, and it would be very difficult to then bypass the devolved administrations in trying to make something like that happen. So I'm not sure what the intention is here, if the intention is to bypass or if the intention is to work together. I'm sure from a population perspective, a promise of new investment will be a broadly welcome one. But if it's about, I mean, it becomes problematic if it is then used to undermine a decision that has already been taken by a devolved government. And clearly the issue of the bypass is one of those examples. But we don't know, and there's just so little detail in the bill around that. But for larger projects, it will intersect with other areas of devolved competence anyway, and even some of the smaller ones might do too. So there will be a need for some sort of cooperative arrangements with the devolved institutions. Otherwise, we just end up getting into sort of tension and conflict in politics, actually.
So it may be then potentially from your point of view that something like planning, which might be integral to things like this, might be best brought back and re-reserved with the UK government then?
No, that's certainly not what I'm suggesting here at all. And that would be perhaps even more provocative than what we have in the bill as it stands, and that's pretty provocative.
Okay. Professor McHarg?
Yeah, I mean, I think Nicola is right that it will depend on how this power is intended to be used, whether it can be done directly with other partners or will inevitably engage some kind of devolved government functions. I think I would be concerned if this is used to directly contradict a devolved government decision. So a decision has been taken not to do X, but the UK government comes in and decides to fund X. I'm much less concerned about the idea of there being plural sources of funding that local authorities and other, other non-governmental organisations can tap into, where there isn't that direct conflict with devolved functions. But I mean, looking at the definitions in the Act. So if we look at clause 48.2, infrastructure is defined as including court or prison facilities. Now, prisons and the court system in Scotland is a clearly devolved matter. I can't see any justification for the UK government, overriding or seeking to override decisions of the Scottish ministers in those circumstances. So I'm just not sure why that kind of thing. Why would you permit a power that could be used in that in that sort of way, where you are centrally dealing with devolved functions. So it's all very unclear how this is going to be used, and what kinds of conflicts might arise out of that. But it looks to me like a power that has the potential to create conflict, and that's a problem.
Thank you, Professor Hunt.
I have nothing further to add to that. I mean, that's all been very comprehensively addressed.
Okay, no problem. In that case, Professor Hunt, we'll start with you and ask my next question is the use of these extra spending powers. Do you think that they might have an impact on Barnett consequential funding that is given in any way at all?
Well, I mean, and again, we don't know. And if they are, obviously, if they as has been referred to already, the EU-based funding has been on a needs-based approach. And if it is sort of Barnetized, then that would be sort of problematic from a Wales perspective. But again, we have no clarity on this.
Okay. Professor McHarg?
Again, we don't know. I mean, I think this is the other concern I would have about this power. So the one is if it could be used to directly contradict devolved decision making. The other is if it's used to kind of divert funds that would otherwise be available to the devolved governments. But we don't know. We simply don't know.
And the suggestion that has been made is that the two would be separate. So this the statements that I have read in relation to the spending power suggest that it would be outside of the normal funding arrangements. But it seems to me that the purpose of the power is to enable the UK government to spend in devolved areas in the devolved territories, and obviously that's quite different from Barnett consequentials, which is as a result of spending in England with knock-on effects for the block grants that go to the devolved institutions. So, but again, we, as everyone has been saying, and it's probably frustrating for the committee to hear, we don't know the answer to this because the detail has just not been provided, not in the bill, not in the surrounding documentation.
Okay, I have another question, but it might be a little inflammatory. So at this moment, I will hand back to the chair, and I might jump back in with it later on. Thank you.
Okay, thank you, Rob. I think Beth's got a supplementary on this group, and then we'll be taking Geraint Davis. Another question from Geraint. Oh, sorry, I see Robin wants a supplementary as well. But Beth, first of all, you please.
Well, just I suppose picking up on what's been said about bypassing Welsh Government, the Secretary of State on the weekend made it quite clear in relation to the M4 road that the intention is there to use the powers within the bill to bypass if necessary. So I think there's obviously a very distinct difference between being able to and justification and actually the intention. And I think it's quite clear that from his comments on the weekend, that is the intention. I don't know if anybody on the panel feels able to respond on sort of that direct opinion that I've just expressed.
I suppose just to say that we have had similar expressed opinions in Scotland as well, not around specific examples so much, but as a general way to promote the presence of and the visibility of the UK government in the devolved territories. And I think there has been a concern, particularly in relation to Scotland, because the question of the union is more prominent there. I think there has been a concern on the part of the UK government, and it was there within the previous administration as well, that the visibility of the UK government was perhaps not quite as prominent as it could have been. I I suppose my response to that would be a less provocative way to manage that would be to be more visible within areas of reserve competence that still have a very large effect in the devolved territories. Now, on the specific example that you're giving around the M4 road, then you could see that there might be an internal market link there if it's about strengthening infrastructure across the transport infrastructure across the United Kingdom. But again, there are different ways to approach this, and either you have a system of devolution that you celebrate and respect, or you risk undermining it and politicizing all of these issues. And that's one way to go. That's one strategy. But there are others that in the longer term might be more effective.
Okay. Robin, did you have a supplementary?
Thanks, Chair. Yes, it's Professor McHarg. In relation to your answer there, you mentioned section 48.2 of the bill. My understanding is that refers to state aid or subsidies. It would seem to be perfectly sensible to have a capacity to prevent one country within the UK from supporting products and providing state aid provisions, and therefore it seems eminently sensible that is a reserved power in the same way as the EU reserved that and prevented, for example, the UK from subsidising its products through state aid.
No, that's not about the reservation of state aid. Clause 48 is about this power to provide financial assistance that we're talking about. The reservation of state aid is now clause 50 in part 7 of the bill.
I'm sorry, I'm clearly looking at a different version of the UK bill.
Sorry, is there a question, Robin, or what's?
We're disagreeing over the versions of the bill that we're looking at. So I'm happy, Chair. I've made my point. Thank you.
Okay, thank you. So, Geraint Davis.
Yeah, thank you, Chair. Can I start with Professor McEwen? You may know, obviously, Wales receives a lot of EU funding, 375 million a year, to alleviate poverty in West Wales and the valleys, poorest parts of Wales. And there is some talk that that money will be taken from poverty alleviation and promoting prosperity and spent on a motorway, M4 Relief Road, to connect with England, as opposed to, for instance, investing in railway infrastructure, where Wales has had only 1.5% of the UK funding for 5% of the population. So do you think there's a danger here that this internal market will enable the Westminster government to spend money on its priorities rather than Wales's priorities, like connectivity and alleviating poverty?
Well, I don't think it's the internal market so much that's contributing to that. It's this general spending power, the financial assistance
that's what I meant.
powers, which are part of the bill, but not really very strongly related to the main purpose of the bill, which is around market access principles. And reflecting on the discussion that we have just had, we just don't know what the intention will be with the use of these spending powers. And it does seem to be the case, at least, that they potentially go considerably beyond the replacement of structural funding. The accompanying documentation talks about COVID recovery funding as well, which we might expect to be greater. So, and again, we don't know if there will be an opportunity for the governments to agree what the priorities would be, or indeed for the Welsh government and the other devolved governments to set their own priorities. We just don't know. And I think one of the things I would hope would come out of the debate when the bill comes back to the Commons is just for the government to be pushed more on what the details of all of these provisions would be.
Okay, Professor McHarg, the EU structural funding of 375 million a year given to Wales to alleviate poverty is currently used to respond to the COVID crisis, because the money we get for COVID doesn't take account of the fact that Wales is sicker, older, and more rural and poorer. So there's a worry if that money is put by the UK government into the Shared Prosperity Fund and spent on a road, for example, that when we move into January, we won't have the money to respond to COVID. Do you think that, you know, that sort of reuse of EU funding or substitute, you know, is appropriate? I mean, presumably that will be enabled through this act. That's correct, isn't it?
Well, I mean, I think it would be enabled in the sense that your original question is, would this allow money to be spent according to UK government priorities rather than devolved priorities? I think the answer to that is, well, yes, because it's a power for the UK government, and there's no obligation to consult or get consent. So I think, you know, there's no doubt that it will be UK government priorities that determine it. What those priorities will be, you know, your guess is as good as mine.
But if they want to spend it on a road into England, you know, at a time that we're concerned about, I don't know, air quality, and we want to build roads, railways, home, is there anything to stop them?
Not that I can see.
Okay, thank you, Chair.
Very much. Simon Baines, please.
Thank you, Chair. Apologies again. I was in the chamber earlier on, but I have heard much of the discussion nonetheless. And I too would like to thank the panellists for their time today. I want to move on to state aid, which we started to touch on earlier. Given that the UK Parliament is the sovereign legislature, as we've discussed, and provides the finance for state aid, what are the practical implications of the UK government making state aid a reserved competence, particularly given that many industries like steel and aerospace are truly UK-wide businesses? Start with Professor McHarg.
Well, some of the budgets for the Scottish Government and the Welsh Government come from UK finance, some comes from local taxation. The implication of reservation of state aid is not to stop the devolved government's spending, but to allow the UK government, UK Parliament, to set the framework within which spending takes place. So currently that framework is provided by EU law. Certain types of aids are permitted or not permitted. There's a process for granting approval to certain types of state aid. That process. So what we're talking about is the replication of that process. We're not talking about spending being arrogated to the UK government. So all that this bill does is take away the power from the devolved legislatures to set rules around about subsidies. Now, what we don't know is what kind of framework at UK level will replace the current EU state aid process. That will partly depend on the outcome of current negotiations, because state aid is with the EU, state aid is a big part of that, and it will depend on political choices made at the UK level. There could be a very strict state aid regime approximating to the current EU regime, or there could be a very lax regime approximating more to WTO law. So that's what we're talking about. It's about the ability to set the rules about what money can and cannot be spent on, and what kind of approvals are required or not. We're not talking about the ability to spend per se.
Professor Hunt?
Yes, if I may come in here. Obviously, the EU state aid regime that is operated and applied across the UK, it's one that the UK has made comparatively little use of. It hasn't spent under those state aid rules to the same degree as other countries have spent. So On some level, we might be feeling surprised that there is this battle over whether or not the UK can introduce a more lax regime. It's not agreeing to having the same regime as it had previously under the EU system. But perhaps there is going to be a renewed focus on spending and on providing aid in this way. But from a devolution perspective, and the fact that effectively these weren't necessarily reserved powers under the previous, under the devolution settlement, that these were areas that had fallen within devolved competence for their exercise, just as the UK Parliament couldn't set a state aid system because it was bound by the EU system. That why is this not a system that is being co-created through the Common Frameworks approach? It sort of appeared on that list from time to time, but it's not, that doesn't seem to be at all the way that this is going to progress, that this might be a sort of top-down process. The Westminster Parliament creates that system and sets the priorities for the UK.
For that, I mean, I'll ask Professor McEwen to come in to round off the question, but presumably part of the benefit of having left the EU is that it gives us much greater flexibility with regard to our approach to state aid. So Professor McEwen, please.
Yes, I mean, I think that the fact that this is in the bill suggests that, as you're probably aware, that within the Common Frameworks analysis, there was a dispute about where competence lay around state aid. The devolved governments said it was devolved, and the UK government said it was reserved. The fact that it's in the bill as a reservation suggests that there was not sufficient confidence in the initial judgment that it was a reserved matter. I'm fascinated by the discussions that we've been hearing today and more generally around a re-emphasis of the sovereignty of the UK Parliament. Of course, the UK Parliament is sovereign, but in creating devolved institutions, it accepted de facto limits on that sovereignty. And this is an example of one of those areas. And yes, of course, that was within the context of the European Union. And perhaps when you exit the European Union, it's appropriate to think that through again. And there is a strong case to make for, in the case of state aid, having a UK-wide state aid regime. Strong arguments to make for that. But that doesn't necessarily mean that you have to re-reserve, that you have to centralise, that the decision has to be made by the UK Parliament and applicable everywhere. There are other ways. And in other countries that have systems of multi-level government, there tends to be more effective processes to bring the governments together in areas of mutual interest and in areas of overlapping competence. And again, if we had better systems and if we had perhaps more trust between the administrations, there might have been scope to do that in the area of state aid as well. But we just don't know, again, what the details will be of this. We have not seen any proposals, or certainly I have not seen any proposals around what a UK state aid regime will look like. And it's perhaps the one area of the bill that might be influenced by the negotiations with the European Union and whether or not a future trade agreement has any obligations around state aid there as well.
I'll just finish, but with one quick addendum to that. But state aid is one of those areas which is a true UK-wide competence. And surely the fact that we need to keep in balance the union with devolution, this is a classic area where governments work better on a UK-wide basis than on a singular basis. And in a sense, that's implicit within the relationship that currently exists with the EU, where it has a UK-wide competence in this area in terms of what is allowable under state aid or not. So I think this is one of the areas where a union approach is actually very beneficial to the process. Would you agree with that? Yes, please do.
Jump in on that one? You're right that there is a risk if state aid is unregulated, there is a risk of damaging economic competition of different parts of the UK trying to subsidise or spend money to attract businesses in ways that is destabilising and damaging. The reservation of state aid does not necessarily prevent that happening, because it depends entirely on what kind of state aid framework is put in place. Now, if it's a state aid framework that approximates to what we currently have under EU law, then the risk of that kind of economic competition is minimised. If it is something much looser, which is what's been talked about, approximating more to WTO law, then the risk is higher. So there are two necessary steps here to avoid the consequences, to have the kind of union approach that you want. One is to facilitate decision making on a UK-wide basis, which could be done through reservation or it could be done through agreement. But the second and the more important part is getting the agreement, getting the common set of rules, which effectively prevent damaging competition.
Thank you, Simon. Beth Winter.
Thank you, Chair. As you'll be aware, back I think in 2017, the 4 UK nations agreed to develop common frameworks, which I know has already been mentioned during the course of the morning, to enable the functioning of the UK internal market and to make sure the UK could meet its international obligations. Wouldn't it have been better for these shared frameworks to be legislated for, to ensure that the partnership approach continued and that Wales could continue to have a say over the standards, etc., has been discussed this morning? And I'd like to ask that to Professor Hunt, because you've just mentioned the common framework, I think, in your last answer. Thank you.
Thank you. Well, as we've referred to already this morning, that common framework process, it's been in development since 2017, and we are seeing some evidence of some very positive progress about how cooperation and partnership can take place across the UK. And what we don't know, I mean, ideally, within areas of devolved competence, this would be the way to proceed. And we would be giving the 4 nations the space to proceed in that way. We have the power to retain existing EU law that can give us the space to do that, and a commitment not to change from those rules whilst creating these new common frameworks is being undertaken. What we don't know is how those common frameworks are going to relate to the provisions within this internal market bill. And it seems astonishing that that's not been made explicitly clear, or at least the suggestions perhaps that the principles in this bill might sort of cut in to the common frameworks themselves, and there may be some divergence that has been agreed and accepted within the common frameworks that might still fall foul of these internal market principles. And again, there's concerns there about how that sort of positive collaborative process has been undertaken that might be undermined by the sort of the top-down provisions within this bill.
Thank you. Professor McHarg, please.
I mean, yeah, I would agree with what Professor Hunt has just said. That there is a risk if the 2 processes operate in parallel, that any agreements are just going to be undercut because any divergent rules that are agreed through the common framework process, and that's the point of a common framework, is to balance common standards with ability to diverge, that then those simply get set aside because they don't have to be complied with by incoming producers. So I think that's really, really problematic. Where a common framework is contained in legislation, which applies throughout the UK, then I think it would not be subject to to the common framework, to the internal market principles. But again, that's not 100% clear. And that relationship really does need to be clear, because there is no point in spending time and effort agreeing common principles and agreeing scope for divergence if then, these cross-cutting rules just undermine it.
I mean, could I come back? So the UK government has argued that the internal market bill is there to fill gaps that exist in the common framework. Is there any merit in that argument? Or again, can I go back to the original question about the fact that the common framework could have been legislated and those gaps filled in during that process?
Well, I think there is some merit in the argument. I mean, a common framework approach is by definition a sectoral approach. And so there may be some unanticipated divergence that arises in an area not covered by a common framework, and therefore you might want some kind of backstop. Of course, that backstop doesn't have to be this whole, architecture of internal market rules. There is always a backstop. That backstop could be agreement. That backstop could be the ability of the UK Parliament to legislate, and the same goes for issues that might arise under new trade deals that was mentioned earlier. That's a big area of uncertainty about what future regulatory standards might need to be. So that goes back to the justification for this large and intrusive set of principles. Is the potential problem really big enough to justify all this, particularly when it might actually have the effect of undermining any agreements that have been reached because the relationship has not been made clear?
Thank you. And finally, Professor McEwen, have you got anything you wanted to add? I'm conscious of time.
Yeah, sorry. Just the rationale for all of this, whether it's frameworks or whether it's the internal market bill, is moving away from the EU regulatory framework. Now, the framework's work streams have been looking at existing EU regulations that intersect with devolved competence for a long time. And they have come to the conclusion that not very many of these require a framework at all. And in the latest analysis, they're talking about of the 154, 22 they think require a non-legislative framework and 18 a legislative framework. And the rest don't require anything. And so it seems to me that if you have something that is a backstop that might sweep up everything else, then you end up potentially undermining that analysis that has suggested that actually you don't really need anything in these areas at all. And one of the common frameworks work started with a set of principles that I think have been quite important in guiding the work. I was a little bit skeptical of those principles because, like many statements, they can mean many different things to different people. But one of the important ones was enabling the function of the UK internal market while acknowledging policy divergence. And it seems that in one sense, the UK internal market bill will still acknowledge policy divergence because it doesn't necessarily stop it from happening, it just weakens its impact. And it's the assumption built into this legislation is that divergence is a harm. And as we've been trying to suggest all along, that isn't necessarily the case, and it depends on the societal ambitions and so on. And so I do think there is a real concern that the bill will affect and undermine the work that has been taking place within common frameworks. But I acknowledge that it might be possible, it might be necessary to have something that is beyond the specific sectoral approach of the frameworks, but we just don't know that yet. And I haven't seen a case made for why there is a need to do that in anticipation of a possible issue emerging at some point in the future, given everything, all of the implications of, and the political implications and consequences of what doing that will do to the relations between the governments.
Thank you very much. Thank you, Chair.
Beth, thank you very much, and that brings us to the conclusion of our proceedings this morning. We're just about to hit our limit just before 11:30. So can I just say again, thank you very much to our panellists this morning, Professor McHarg, Professor Joe Hunt and Professor Nicola McEwen. Really appreciate your time, and it's been a very, very useful session. And my thanks as well to my fellow committee members for making this a very, very useful meeting. Thank you. Have a great day.